Construction defects are defined as various types of faults, defects, or failures that are usually discovered in apartments purchased from a contractor. These defects can significantly impair the value of the property, its integrity, appearance, and the enjoyment of its users. Many homebuyers come across contractors who are indifferent to the problem and this situation and end up in a situation where they are facing a broken trough. In order to deal with construction defects in a good and correct manner, it is recommended to contact an expert and experienced real estate lawyer in order to ensure effective and prompt treatment of failures and hazards and to receive maximum compensation. What are construction defects? Construction defects are any improper condition and defect that is discovered in the apartment in relation to what was agreed and promised in the contract that deviates from the Israeli standard and for which it is possible to file a claim for compensation from the contractor. There are several defects that can be distinguished and defined as construction defects. For example, if the technical specification of the property was promised and agreed on ceiling height, wall width, etc., unlike the product, the finished property was delivered and actually received. Another situation that is a reason to file a claim for compensation is when it comes to construction that does not meet the Israeli standard and standard required for construction according to the law, and the apartment was built using poor materials that over time can give signs and manifest in cracks, gaps, and water leakage that causes moisture. All these and other failures and defects must be repaired before purchasing the apartment or in the inspection year at the latest. It is important to emphasize and note that if you have located any defects in the apartment you are about to purchase and you are debating whether they are compensable. Types of construction defects that are common. Aesthetic construction defects. These are construction defects that damage the appearance and aesthetics of the building, such as cladding or fallen mosaic stones. These defects do not detract from your right to contact the contractor and demand that he corrects the default. Damage construction defects. Construction defects that may affect or damage the structure and property located in the apartment, and these defects are liable to be filed against the contractor. Safety construction defects. Artificial construction defects are considered very serious and constitute a tangible and clear danger to those who live in the apartment, such as a wall that is prone to fall due to negligent construction. In such a situation, you must immediately contact the operating contractor and without delay contact a lawyer who specializes in construction defects. The failure and problem immediately and urgently. Delay in delivery of the apartment. The legislature and the case law consider the need to protect buyers of real estate, apartments and offices from developers and contractors, while establishing a framework of laws between which one can find the sale law, which establishes a system of debts between the contractor and the buyer. In this way, the legislature strengthens and complements the certainty and supervision of the purchasers. However, there are quite a few cases of developers and contractors who break the law and significantly infringe on the rights of purchasers. According to the sale law, a delay in handing over an apartment is a situation in which more than 60 days have passed since the contractor promised the buyer that the apartment will be delivered to him, and therefore, starting on the 61st day, it is a delay that justifies filing a claim depending on the size of the apartment, its location, and the cost of renting similar apartments in the same environment. There are cases where the terms that appear in the agreement signed with the contractor benefit the buyer or buyers, and therefore, consultation with a real estate lawyer and real estate. Filing a claim for construction defects. If you find any defects in the structure you purchased and you intend to file a claim against the contractor, or alternatively, if you purchased a second-hand apartment and defects were discovered that were hidden from you and you want to sue the seller, it is important to understand that not all are dissatisfied with the product you received. Filing a claim, get an opinion from an expert in the field of construction defects who will give his professional opinion on the omissions and failures and give an estimate regarding the cost of repairing them. Without obtaining an expert opinion and professional legal assistance from an experienced real estate lawyer, a lawsuit cannot be filed, because the legal argument is based primarily on the opinion revealing failures and defects in the apartment for which the contractor is responsible or the seller tried to hide. The main reason for filing a lawsuit with the opinion of an expert in the field is that in most cases, the sitting judge does not understand or is able to quantify whether there are indeed construction defects in the apartment or not, and therefore an expert examination is and serves as eyes for the court. When to file a construction defects claim. There are construction defects of various types and in varying degrees of severity, ranging from minor defects that can be repaired relatively easily to safety failures materials that pose a real-life hazard. In most cases, construction defects can be repaired, and if there was no malicious intent on the part of the contractor or seller, then it is possible to request that the defects be repaired at the expense of the contractor or seller. In cases where construction defects have been hidden or caused due to negligence, but their repair cost and severity are not particularly great, it is possible and recommended to file a small claim in the small claims court accompanied by a lawyer who specializes in the field to get adequate compensation and make sure all defects and defects are repaired. When it comes to purchasing a new apartment, first-hand from a contractor, already upon receipt of the key, it is important to make a delivery protocol where tenants have the right and opportunity to clearly and in detail list all the defects that are discovered in their new apartment. For all these defects and also for defects discovered during the test year, grounds for filing a claim for construction defects. For you as home buyers, it is important to find out during this period any defect, failure, or defect including moisture and leaks, door leaks, cracks, safety hazards, water drainage indemnities, and more, and after discovering all those defects, contact the contractor and inform him immediately and send an orderly letter regarding the defects found in the apartment, including a demand to repair them within a reasonable period of time. If the contractor refuses to repair the defects, some or all of them, and this despite the option given to him, he is at that moment exposed to a lawsuit. In any case where construction defects were discovered in the apartment you purchased, it is recommended that you contact a construction defects lawyer and small claims lawyer as soon as possible in order to receive guidance, advice, and legal representation throughout all stages of the claim submission process. The lawyer will know to which category the claim belongs, whether it is defects and damages that belong to the category of small claims, or whether it is failures and serious damages for which a standard tort and compensation claim must be filed. What are the defects and failures that can be generalized in filing a construction defects claim? Charging the developer or contractor with the repair of the defects discovered, i.e., a requirement to actually repair them, and if this is not practically possible or the contractor was given a suitable opportunity to do so, but this was not done, then monetary relief will be required. If it is determined that there is a structural defect that cannot be repaired, and that it constitutes a decrease in the value of the property, then the decrease in value can be claimed with monetary value. If the contractor or developer was late in delivering the property to the buyer of the property has the right to claim adequate compensation for the delay in delivery. Supplementary compensation. The claim may also include a component and relief of mental distress caused to the buyer due to the necessity to find an alternative housing solution, unplanned expenses, loss of income, and other various components that are suitable for each case and its circumstances and are compensable. What to do when construction defects are discovered. The first step that is important to take after discovering construction defects is to document all the defects, as well as the causes of these defects, and contact a lawyer specializing in construction defects as soon as possible. It is important to notify regarding the construction defects that have been identified, cracks, greens, leaks, and moisture damage, immediately upon the discovery of the construction defect, and it should be known that the statute of limitations is 7 years from the date of discovery of the damage. It should be borne in mind that construction defects can be misleading because they may expand, develop, and spread even long after they were first discovered. Therefore, when construction defects are first discovered, it is important to know and understand that there is no guarantee that no further defects will be discovered later on for which a claim will need to be filed. Checked company and expert opinion. With the discovery of construction defects in the property, it is advisable to order a home inspection company as soon as possible, perhaps through a law firm, which will perform a thorough and comprehensive inspection regarding construction defects and their origin. Whether it is defects that are the result of leaks and moisture, mold and mildew problems, or whether it is structural defects and cracks that exist in the ceilings and walls of the house, it is important and mandatory to invite professionals and an inspection company to assess the damage and know how and from what they were created. In many cases, the opinion of an engineer, real estate appraiser, or land consultant will be needed to accurately assess the reasons for the formation of the defects and to assess the severity of the damage caused as a result of the construction defects. The professional opinion will form part of the statement of claim and an important appendix to any claim for construction defects or a claim filed against a contractor, because alongside legal assistance, only professionals with appropriate experience and certification will be able to establish the damage and defects estimated in the statement of claim and demand adequate compensation accordingly. Once discovered, you can bring your claims to law offices around Israel to deal with this issue. Sending a warning letter before filing a claim. Once it is found that the construction defects were caused due to negligence on the part of the contractor, engineer, or any other party, it is advisable to send a warning letter before taking legal action against that party in an attempt to reach agreement and an equal value without filing a lawsuit. The work of editing, sending, and delivering the letter, it is recommended to let an expert lawyer perform in a serious and professional manner. Filing a claim for construction defects accompanied by a real estate lawyer and expert real estate. In any case where you intend to file a small or ordinary claim for construction defects, it is important to make sure that you have all the certificates, documents, and references that indicate the construction defects discovered in the property. To the statement of claim, it is desirable and important to attach opinions from experts in real estate and law who are professionals, real estate appraisers, building engineers and inspection companies, and of course photos and videos that can attest to the defects, their severity, and the damage they cause to the property. The claim must be filed with the assistance of a real estate attorney who specializes in construction defects, who will draft and prepare the statement of claim and submit it to the court. The law firm and notary Han specializes in accompanying and representing clients in a variety of cases and lawsuits in the field of civil law, commercial, real estate, construction defects and small claims, inheritances and wills, execution, and more. The team of lawyers in our firm has experience and expertise in handling and managing complex cases, all while working tirelessly to achieve the desired legal result and exercise your rights. We are at your service, and we will be happy to provide you with a professional answer to any question, inquiry, and problem with a personal attitude, responsibility, and dedication.